Hello everyone, welcome back to the Margdarshak YouTube platform. So as you people are aware that we are doing the Polity series. In this we are discussing polity in a basic to advanced manner. In this series we are already done with the two lectures. First lecture is also all about the rules and regulations made by the Britishers from 1773 to 1947. Then in the next part we have discussed about the making of Indian Constitution and the necessary steps and the important step that was taken during the making of the Indian Constitution. We have discussed in the last lecture. So in today's lecture we will going to discuss about the next part of our series, that is the features of Indian Constitution. The constitution that was made by our constituent assembly, we will discuss the feature of that constitution that we can see the constitution that we are using today. We will discuss the features of that constitution. Okay, so without wasting any time, let's further move towards the chapter. Okay, but before starting the chapter, let me tell you one thing, that if you are not part of our mentorship program, that is Margdarshak mentorship program, and if you really wanted to prepare for the examination with the right strategy, right guidance, and with the toppers approach, then you can definitely join our mentorship program that is free for all of you. You can just go in the description box and you can just fill the Google form where you will get the mentorship call support free of cost. You don't have to pay anything. You can ask any of your doubt. Okay, so that is all about our mentorship program. I will also share you about my Telegram channel, where I will share the PDF of these lectures as well as the further notifications about the classes, as well as we are also discussing something about for the exam oriented in our Telegram channel. So you can also refer to that Telegram channel and you can join there. Okay, if the link of the description box about the Telegram channel is not working, I will provide a QR code in the last slide of this lecture. You can join the Telegram channel from that QR code. Okay, so let's discuss the features of Indian Constitution. So basically, let's move towards that. So basically, if we discuss about the features of our constitution, then first and foremost thing that we have discussed about the length of the constitution. Basically, let me tell you one thing, that there are two type of constitutions. So let me just make my pen clear for me. Okay, give me a second. Okay, so basically there are two type of constitution. First is written and second is unwritten. Okay, so basically India has adopted the written part of the constitution. Okay, so we can say, and as well as India has lot of from the in the original constitution we had 395 articles, 22 part divided in 22 parts and 8 schedules. Okay, so this make the our Indian constitution the lengthiest constitution of the world. Okay, lengthiest written constitution of the world. Let me just complete the sentence. Okay, but now with the amendments and with the requirements of the current scenarios, the articles in the constitution has increased from 395 to more than 470. The parts are increased from 22 to 25. The schedules are increased from 8 to 12. That is the evolution and the amendment that is required for the contemporary needs, and for that the amendments and the necessary things are added in the constitution. That is mentioned here, that there are number of articles has increased, parts also increase, and the schedules also increase. Let's discuss why it was the lengthiest constitution, why there is a need to make it such a lengthy or such a bulky book of the constitution. So you may know that the geographical extent of India is very very vast, where we have mountains, plains, as well as the you can say the islands and the Thar desert, and you can say plains as well. So you can say that diversity of country, as well as this is the diversity of the terrain. Now let's discuss about diversity of the culture and traditions, about the religions. So to take care of all these things, there is a high need to make the constitution more bulky and more lengthy compared to the other countries where they have like less diversity or higher similarities. So that is one of the reason for the lengthiest written constitution, as well as this constitution of India also have detailed administrative provisions. Yani, this means that this constitution discuss everything in detail, so that so that the people or the citizens or the administrators don't feel confused about the terms and the conditions. This was one of the fantastic thing that the constitution makers, the policy makers, has done to the constitution, to make it the broad and elaborate form of a constitution that will provide everything in it. You don't have to read anything else other than the constitution. The interpretation of the constitution by Supreme Court, by the governments, and by the administrations is the only source for the country's well-beings. Okay, next is basically one more reason is that it was borrowing from many constitutions. Okay, so basically this constitution is not from the scratch, like it was and is from the scratch. But what our constitution makers did, they borrowed these things from different, they compiled the good things from many countries constitutions, such as UK, USA, Ireland, France, etc. So simultaneously they also took help from 1935 act, Indian Council Act of 1935, and with the base of these things they make the constitution that is for the well-being and for the welfare of the all people in the country. Okay, so that is about the why the constitution was lengthiest. Let's move towards the next part of this, next feature of the constitution, that is it was drawn from from various sources. As I mentioned earlier, that it was the constitution makers, the strength or ability or their futuristic view, that they took help from the different type of different countries constitution, so that they can make best version of the constitution. Okay, and they made this as the one of the best constitution of the world, that is still have some records in it. Okay, so basically drawn from various sources, but the structure of this constitution was based on the 1935 act, that is the Indian Act of Government of India Act 1935. So basically structure part is taken from here, and other constitutions was taken from the other countries, like the fundamental rights are taken from USA, the parliamentary system was taken from the UK. Okay, the you can say the quasi federal system was taken from Canada. Ireland, say we have directive principles of the state policy are from the Ireland. Okay, and fundamental duties are from the USSR. So that is the thing that we have borrowed from the different constitutions, and we have inculcated everything in our constitution. Let's move towards the next thing, that is the blend. The constitution is the blend of rigidity and complexity. So basically if we compare the UK and US constitution, so you will feel that the constitution of UK is a flexible constitution, means making any amendment is very easy in the UK's constitution, while if you see the USA's constitution, you will find the constitution is very rigid. If you have to make an amendment, there is bulky procedure that you have to follow to make any type of amendment. But India, or the constitutional makers, the fathers of our constitution, have seen these things, like if we make these things very rigid or very easy, then there are these are the extremities. We have to take the middle path, where the mix of we have to go with the mix of both, so that our constitution can be amended with some procedures, so that we can feel the demand, we can fulfill the demand of the contemporary, future times. Okay, so that is why we have adopted the rigidity and complexity, and the blend of the rigidity and complexity in our constitution. Okay, so basically rigidity, that certain provisions require special majority of the parliament plus consent of the half of the state. Okay, and flexibility, many provisions can be amended by simple majority. That is, we can say the blend of rigidity and complexity in our constitution. Let's move towards the next thing, that is the federal system with a unitary bias. You can say the quasi federal system. So basically, that federal system with unitary bias means that India is definitely have a federal features such as the division of powers, like our like the due to like the powers are divided among the state, among between the center and state, as well as with some powers with the local government or grassroots government. So this is the about the division of power. Like we have divided the power on in schedule. Seven of the constitution also mentioned about the division of powers, that we have divided in the center, state, and concurrent list. Also we have divided, we have that division of power, as well as we have bicameral legislation, है ना? That means we have two legislative count, like one is legislative assembly, as well as one is the assembly and the second is the council. Okay, so that is about bicameral. And we have independent judiciary, yani ki that is the feature of our federal system, that our judiciary is independent of the executive and the legislative part, that make our judiciary independent from the rulings of the country, and it make the our judiciary more efficient to take the decisions, to take the efforts for the citizens. Next is the next talking about the tilt of our constitution from federal only towards the federal system with the unitary bias. So unitary bias is basically the powers are centered in the one authority, that is the unitary feature. That is that we have strong center. Like if we see about the division of power, we will find there are like in a center, some power is center, some power in state, and some power in the concurrent list, as well as some residual some residual powers are also available, but these powers are with the center. And if the center wanted, and if there are any needs, like if there is to take an example of, if there is any foreign interest or any of the binding things, then still then the center can make the laws on the state list as well. While on the concurrent list, talking about the concurrent list, then we can say that in the concurrent list, the laws made by the center is prevailing over the laws made by the state. So that is also about the strong centers power. Okay, next is the emergency provisions. So basically emergency provisions mentioned in the article 320 352, 356 and 360 also meant about the emergency provisions, that shows the unitary power, unity tilt. That means that if there is any emergency situation, such as national security or the president rule or any financial instability, financial emergency, then the union's laws are prevail over the state laws. Means union has all powers to take control of the over the states in the situations of the emergencies. That is shows about the unitary feature. Next is the single citizenship. Basically we will discuss the single citizenship in some in the next slide, but we have a different slide, but let's discuss the single citizenship here. So single citizenship is not about ki yaar you can take citizenship of single city. Yeah, single citizenship is the only the one citizenship. Okay, it doesn't mean ki yaar, if you have double citizenship, yani then dual citizenship, then you can take citizenship of India and USA. When I was preparing for the examination, when I started preparing for the preparing the polity, then when I see the single citizenship, I thought ki the single citizenship means we can take only India citizenship, and dual citizenship means we can take India citizenship as well as some other countries citizenship. But that is not at all correct. That is I was wrong. And because of my personality as an introvert, I never asked my teacher about the single citizenship. I interpreted it according to myself, that it is a single citizenship means you can take citizenship of the one state, one country, and you can take the citizenship of other countries simultaneously. Okay, but that is wrong. Single citizenship is that you have the only one citizenship, like there is like for country, that for India, take an example of India have single citizenship, while USA have dual citizenship, where the people enjoy the state's citizenship as well as the center citizenship or the USA. Like take an example that one person from the California, enjoy the citizenship of California as a state of USA and the citizenship of the USA, है ना? So that is the difference between single and dual citizenship. I hope you understood this, and I want to clear this doubt because I also had this doubt and I interpreted it wrong in my preparation. So I want you to please clear in your mind that single citizenship is the only citizen, the one citizenship for a whole the nation, while the dual citizenship is like for the whole country there is one citizenship for the center, and for the different states there was different citizenship according to their states. So that is dual citizenship. I hope you understood. Single citizenship in the UK and India part, and dual citizenship you can say in the USA. That is the citizenship part. Let's move toward the parliamentary form of government. Like next feature is the parliamentary form of the government. So let me tell you that why India adopted parliamentary form of the government. There are two form of the government: parliamentary form of government and presidential form of the government. There are two type of government form of government. First is parliament and second is presidential form of the government you can see in the USA, while parliamentary form of government you can say in India and UK. Okay, so why India adopted the parliamentary form of the government? So basically India adopted the parliamentary form of government from the UK's constitution. It has lot of reasons, because we as a country of country of diversity and variations, we thought that if we want to inculcate the whole people, whole representation of the different part of the country, then we have to make a parliament where we can discuss things. Okay, we can make decisions on the parliamentary basis, okay, with their decisions, है ना? Simultaneously we also face, or we have experienced the parliamentary form of government during the British rule. So that is why we have seen the parliamentary form of government there, its impacts, its negative as well as positive, and its importance we have seen, its significance also we have seen in during the British rule. So that is why we adopted the parliamentary form of government. This was based on the British model. So basically British parliament is also known as Westminster Parliament. Okay, so basically it is in Westminster, so that is also called Westminster Parliament, and it is called the Westminster model of the parliament we have adopted. Okay, so basically यहाँ पे क्या होता है, here you will find that there is a collective responsibility of council ministers to the Lok Sabha. Okay, so in the parliament the Lok Sabha, the council of ministers are collectively responsible towards the Lok Sabha, while in the presidential form it is not correct. So that is why one of the reason is that yes, the to make the cabinet or the council of the minister responsible towards the Lok Sabha, and finally we can say if Lok Sabha, then the people of India. Okay, next is the prime minister is the real executive head हो गया, है ना, of the parliament. Okay, so next is the synthesis of parliamentary sovereignty and judicial supremacy. As I told that parliamentary sovereignty, यानी कि parliament is sovereign to take decisions without any of the pressure from any external things. Like let's take an example, like India's parliament is free to take decisions. इस पे कोई there is no pressure from outside the country, like UK is not going to force, or USA is not going to force the parliament of India to make laws according to themselves, according to their requirements. The parliament is free to make laws, है ना, for the convenience of the people. Okay, and simultaneously India adopted the judicial review, like the USA, like UK USA part. Judicial review, what judicial review means that if government has made any law, any type of law, then judiciary or any type of decisions, any type of bill, then or any type of act is done by the parliament, है ना, or any body, है ना. Then the Supreme Court Supreme Court or High Court have the jurisdiction to discuss to review their judicial their legality and judicial things according to the need of the people. If they are not judicially viable, then the Supreme Court or the court or High Court can make them null and void, and can order the parliament to amend these things according to the needs. So that is about the judicial review. We have taken the judicial review part from the USA. Let's talk about the basic structure doctrine, that is also limits the parliamentary power. So basically ये है ना, basic structure doctrine was first come in the force during the Keswananda Bharati case in 1973. So basically the basic structure is that the structure that is the base of our constitution, such as the parliamentary form of government, okay, the election of the president, or you can say the post of the president, or the independent judiciary ho gaya. So that is the basic stuff basic structure of our constitution. Okay, so let's move toward the next, that is the independent and integrated judiciary. As I discussed the judiciary in the earlier episodes, or earlier slides also, let's make it simple and crisp. Basically, the judiciary of India is same as the judiciary of USA, where the judiciary is independent from the executive or legislative powers, as well as the judiciary is integrated. Yani ki there is nothing that ki state judiciary or center judiciary. There is the level of the courts, like now on the top there is a Supreme Court, below the Supreme Court there is High Court, and there the next below the High Court there are subordinate court at the district level. That is the hierarchy. The divide, there is no like the courts are for different, like you can say if there is not an integrated judiciary, then there may be the courts for the different state. Yani we can say for the Rajasthan, take an example of Rajasthan. For the Rajasthan, to take the cases of Rajasthan, there is only one court, that is the court of Rajasthan. Okay, so that is not here in the integrated judiciary part. Okay, here there are subordinate court, that is high courts. High courts appeal can be you can appeal against the high court in the Supreme Court. Okay, that is our judiciary is the integrated and independent. Okay, next is single integrated judicial system with the power of judicial review. As I told you that the judiciary has the power of judicial review on the laws, bills, acts of the parliament. Okay, though our constitution also enshrines the fundamental rights. These rights are basically to safeguard the interest of the people. These rights are enforceable in the courts under like courts can issue writs under Article 32. That is also a fundamental right to safeguard the rights of the citizenship. And the High Court have also the right to issue the writs under Article 226. Okay, so that is the fundamental right. Basically, they are inspired from the USA Bill of the Rights, and they are justiciable and enforceable by court. We will discuss the fundamental rights in the in the next couple of lectures, in the next couple of lectures. Okay, so please here we are just making them just we are doing this something about these things. We are just taking that what we are going to discuss in the next lectures. We are just keeping that in mind, and we are just going through just we are not reading between the line. We are just going through the terms. Okay, next is the directive principle of the state policy, that is DPSP. They are basically the inspired from the Irish constitution. They are non-justiciable. They are only the guidelines for the governance. Okay, so basically these are mentioned in Article 36 to 51. Okay, so next is the fundamental duties. So fundamental duties were initially not part of our constitution, but with the recommendation of Swan Singh committee, Swan Singh committee, these fundamental rights are added in our constitution with the 42nd Amendment Act 1976. Okay, they are inspired from USSR. Okay, so these are under Article 51A. Okay, so these are the fundamental duties. They are not enforceable in the courts. They are they are duties that every citizen of India has to follow and have to adhere to. Okay, next is the secular state. Like in India has secular state. We can say secular state are two type of the negative secularity. negative and positive. Okay, so basically India have negative India has India have positive secularity. So basically positive secular negative secularity means basically mean is that state like in US, in I think in UK, in these Western countries have the negative secular concept, where the church and the religion, church and the sorry the parliament, the government and the religion have are not interlinked at all, है ना. There is no provision for the religion, for any specific religion in their in their the acts and the rights. But in positive secularism, that is part of our Indian constitution, for our Indian constitution, we can say positive secularism, that government is not favoring any particular religion, but to make the betterment for the religion, government can make laws for like for any religion, है ना. That is the positive secular state. Okay, so equal respect for all religions, no official religion, यानी कि in positive religion or in both, यानी there is no official religion, but government can make laws for the respect and dignity of the religion. Okay, and next is universal adult suffrage. So basically India have universal adult suffrage, है ना, यानी कि वन पर्सन वन वोट एंड वन वैल्यू. So basically ना the universal adult suffrage, firstly there was like ना only 21 years old or older than 21 years old can 21 years old can vote in the vote for the candidate. But with the 61st constitutional amendment act, basically 1998 में आया था. Then after it was enforced in 1989, it reduced the age from 21 years to 18 years to vote in the in the elections. Okay, so that is the one vote, that is the universal adult suffrage. Okay, single citizenship, as I already discussed it, that all Indians are citizens of India only. There is no state specific citizenship. Emergency provisions, inspired basically emergency provisions, I already told about, mention about article 252 to 352, 356 and 360. Okay, that is mentioned about the emergency provisions, basically inspired from Weimar constitution of Germany. National, state and financial emergencies, this is the national emergency, this is the state emergency, and this is the financial emergency. Okay, so next is the special provision for certain state or religion. So basically to promote or to help the states like the backward state, or to provide them equity, there are some special provisions that help them to provide special provisions for this is also called asymmetric federalism. Okay, so here article 370 तो abrogate हो गया. Okay, 371 okay, and 371A2J है ना. Okay, so basically यहाँ पे mention they're mentioned about the special privilege and special powers that are given for some states that are mentioned in the article 371A to लेके J तक. Okay, next is the Panchayati Raj and cooperative societies. That is basically Panchayati Raj is 73rd and 74th constitution, Panchayati Raj and the urban local bodies, and with the 97th constitutional amendment act, the cooperative societies are in the play, basically local self government and cooperatives. Okay, so don't worry, we will discuss these things in detail in our upcoming lectures. We are just going through these things to make you aware or understand about the things. Okay, next is this borrowing features, like what we have borrowed from which country. This is mentioned here. Please remember these things. These can be directly asked in your examination. What we have discussed here is not an easy thing. You may directly find one or two direct questions in your examination. If you are preparing for any state PCS or any central government, please remember these things. These can directly quoted in your examination, है ना. So please remember these things, है ना. this is, I think, one of the best lecture, one of the fantastic lecture. If you have nothing, if you just wanted to revise polity, you can just go through this lecture only. This will give you a good edge. Okay, so basically with the UK's parliament, UK के साथ we have borrowed from UK the parliamentary government, rule of law, single citizenship, and the cabinet system. From USA we have taken the fundamental rights, judicial review, and independent of judiciary. We have discussed these things in the earlier slide so as well. Okay, Canada with the, we have discussed the federation with a strong center, that is quasi federalism. Residual power with the center, that is also power of the federation, the quasi federal system. Okay, and with the Ireland we have taken the DPSPs. Okay, nomination of Rajya Sabha members and election of the president we have taken from Ireland. Please remember these things. Okay, USSR we have taken the fundamental duties, that is not part of the original constitution, that are taken with the 42nd Amendment Act 1976. Okay, 1976. Okay, 5-year plans are also taken from USSR. USSR was the first country, or first you can say country or United Union, okay, that implemented the 5-year plans. Okay, so next is the France we have taken from the we have taken the republic, ideal of the liberty, equality, and fraternity from France. Okay, French Revolution we have, and I hope you have studied the French Revolution in your world history. Okay, and you can directly say that the republic, liberty, and the equality and fraternity are taken from the French. Next is the Australia we have from Australia we have taken the concurrent list, freedom of trade, and joint sitting of the parliament we have taken from the Australia. From Germany we have taken the emergency rights. Okay, from South Africa we have taken the procedure for constitutional amendment, election of Rajya Sabha members. Okay, from Japan we have taken the procedure established by the law. So that is the diversity of our Indian constitution that we have taken, and mostly we have taken the Indian Constitution Act, Indian Government Act 1935. Most of the things are taken from, this was the base for our constitution, that we have relied on this, and accordingly we have modified things, that is the need, according to the need. Okay, so next we will discuss the criticism of our constitution, that the different scholars has criticized our constitution. Let's just discuss them here, that is. Okay, so I hope you are here, you are just you are writing the things that I have dictated. Okay, so first criticism is a borrowed constitution. So basically the critics or the scholars or the leaders have commented, have criticized the constitution, that it was borrowed from the multiple constitutions. Okay, and it is a hodgepodge constitution or a patchwork. Okay, so, or it was taken from different part. Okay, so to answer these type of to the critics, the constitutional makers rightly said that there is nothing bad in taking the good things from the different type of constitution. We have taken the good things from different type of constitutions and different type of acts to make our constitution the best constitution of the world, and to fulfill the need of every sectors of the society. That is why we have taken the different part of the different part from different two countries. Second is the carbon copy of 1935 Act, Indian Council Act, Indian Government Act 1935. So to answer this type of this critique, the constitutional makers have rightly said that we have taken the 1935 Act as in base of our constitution, because the 1935 Act was made for the Indian needs, and that was helpful for during our constitution making process to make the things better. So that is why we have taken the 1935 Act as an base for our constitution. Okay, So as the one of the thing that the constitution maker have they rightly said that there is nothing productive in making the sorry, reinventing the wheel. यानी कि the constitution act, the acts and the laws during the 1935 act was for the need of the people. There they some rights, some things are very fantastic for the Indians, so we have taken these things only. We didn't take everything from that. We have taken the good thing from our 1935 act. Okay, un-Indian or British so next is the un-Indian or anti-Indian. So basically, critics have argued that the constitution is un-Indian and anti-Indian because it have taken some of the constitution, some of the concept from the uh, some of the constitution that was prevailed by the Britishers. Okay, so that is why it was said that it is unconstitutional, un-Indian or anti-Indian. The critics also argued that this constitution is their legacy of British, like they are discussed, the discussions are mostly on the English part. Okay, so that is why the critics argued, but the constitution makers have clarified their doubt that the most of the people are educated in English concept and English ways, so that is why the constitution have some portion of the English part or in the Britishers thought, but that can be amended, that we have the right to amend the constitution in the future, so that can be amended. Next is that an un-Gandhian, un-Gandhian. Okay, constitution, the critics also argued that it is an un-Gandhian constitution because the Gandhi's ideas are for the village democracy, but here the concept of the federation with the quasi federation system, so that is why it is also called the un-Gandhian constitution. Okay, and next is the elephant size. Okay, elephant size. Okay, so basically critics argued that the constitution is it was a funny thing that the symbol of our constituent, the making the constituent assembly was an elephant, and they argued that the critics argued that it has taken it seriously and make the constitution elephantine size. So constitutional makers have argued that the India's diversity is very high, and to make this diversity at one place or to address everyone's issues and everyone's rights, we have to make this the constitution elephantine to make to give place for everyone, to specifically mention everything for everyone. We have to make the our constitution at elephant size or the bulky constitution. Next is the paradise for lawyers. Paradise for lawyers. So basically, the critics argued that the constitution is a paradise for the lawyers because then the constitutional makers have rightly answered that the most of the people in our constitution, in the constituent assembly, were related to some legal concepts, so that is why the critics argued that it is a paradise for lawyers. The terms that is used in our constitution are very hard to interpret by the local people, but to answer these things, the constitutional makers have made the point that to make the things very simple, it become very hard for them to make the things very simple, because the terms that are provided in the constitution have some significance, legal significance. That is why to make them simple to decipher or understand by this local the normal people is very hard. So that is why they were criticized for the paradise of the lawyer. So that is for the today's session. I firstly decided that we will also complete the preamble part in this lecture, but now I am for the shifting the preamble part with the next lecture. So in next lecture we will discuss the preamble as well as the territory wala part of the Indian Constitution, that is article 1 to 4 of our constitution. We will do the preamble of the preamble and this part simultaneously. For today we have discussed the feature of our constitution. That is enough for today's class. I don't want to exceed it anymore. If we can, if we are going to expand this will be a negative thing, that you will get bored or you will not get time to study for yourself. So this is for today's class. I will provide the PDF in the Telegram channel. You have to join the Telegram channel. Okay. Okay, so let me tell you, let me just show you the the QR code for the Telegram. If you are not able to decide to join the Telegram channel from the description, then you can just scan this QR code and join the Telegram channel. Okay, so our Telegram channel is Margdarshak by Margdarshan by the Manish. So that is our the Telegram channel. You can join this. Okay, so that all for today. Jai Hind, Jai Bharat. We will meet tomorrow.